Good day, everybody, and welcome back to the show. Today we have our guest, Professor Bruce Pardy, no stranger to you guys, and one of your favorites, I know. And we're going to break down the Referendum Goose Is Cooked. Alberta law prevents a vote for genuine independence. So, welcome back to the show, Bruce.
Thank you, Nadine. Great to be with you.
Y-
Always.
Yeah, well, you were up in Dalhousie, some old stomping grounds of mine, a couple of days ago for a little debate on nonetheless Alberta independence. How did that go?
It was good fun. And that was what we did. I went to Dal out in Halifax to have a debate at the law school on Alberta independence. And it was great to be able to talk about that question out on the East Coast for a change. So my hats off to the organizers, the Runnymede Society, for putting that together.
Now, what was their incentive for doing that?
Well, basically, the Runnymede Society exists to have debates and conversations that nobody else wants to have. And so the law schools each have a chapter of the Runnymede Society, and the students run it. And the students in charge of the DAL chapter said, "Let's do this." So you know, my hats off to them for doing that.
Yeah, I find it fascinating that the conversation is now being had in the East, especially Dalhousie, who, like I said, I spent my first year university there. Wasn't quite so woke back then, but as I understand it, it has become quite woke since. So, um, interesting times.
Well, the other thing that happened to me that was interesting recently, not in Halifax, but in Toronto, I happened to be on the subway in Toronto wearing my Alberta Republic hat, and for the first time, it's not the first time I've worn it, but for the first time, I had people come up to me and say, "Hey, that's a great hat," and, or "Great, let's do that." And one guy actually even offered to buy it off me. So so I don't know if that's an indication of anything, but it just so happened that just in the past few days, suddenly there are people, at least a few of them, thinking that's a great idea.
Yeah, well, maybe they're thinking that it's time for the rest of Canada to do something similar, same as we're seeing it, the conversation spread into Saskatchewan, Newfoundland, Labrador, and other provinces are looking probably at the budget that was released yesterday and going, ha, ha, how do we get out? Can't leave fast enough. Um,
Right. And I've heard you're a big fan of that budget.
yeah, yeah, yeah. We've had that conversation. So Bruce is trying to trigger me right now. Which case, if you're going to do it, the budget is definitely one way to do it. $78 billion deficit. Splitting capital expenditures from operational expenditures. In which case, there's no difference. Debt is debt. You can't borrow your way to prosperity. It's like I'm going to do an entire show on that and do my own rant without wasting Bruce's time. Because we have a very, very important message, I think, to bring to Albertans today. And that's with respect to your article that just came out last week, the Western Standard, the Referendum Goose Is Cooked. Now, Bruce, I'm going to start just with the first line of this.
All right.
It may not be apparent yet, but in Alberta, an independence referendum is verboten. Now, I don't think people understand what the word verboten is. Thank you for putting that in there. The first thing people have to do is pull out the dictionary, but explain what that word means, because I think that word right there sums up exactly the entire theme of your article.
Right. Okay. So what I'm saying is that a referendum for actual genuine independence is effectively prohibited by Alberta law. And that's because of two sections in two Alberta statutes. Now, one of the things I want to emphasize here is that this is Alberta law. This has nothing to do with the federal government, nothing to do with federal law, nothing to do actually with the Constitution, although the Constitution is referred to in these two Alberta sections. Nothing to do with the Supreme Court decision and the reference about the separation of Quebec. This is a made-in-Alberta obstacle. And the obstacle arises because we have these two statutes, two Alberta statutes. One is the Citizen Initiative Act, and the other one is the Referendum Act. And in the Citizen Initiative Act, there is a section 2(4). And the Citizen Initiative Act is a mechanism for citizens of Alberta to initiate referenda proposals, to lay them before the government, and which is great. I mean, we didn't have to have that kind of statute in Alberta, but they decided to have it, which is terrific because the citizens can initiate these things. But because it's a mechanism, the mechanism has requirements. And one of those requirements is section 2(4). And section 2(4), and I'm just gonna read it to you so I get the words exactly right. Section 4 says, an initiative petition proposal must not contravene sections 1 to 35.1 of the Constitution Act 1982. Now, sections 1 to 34 is the Charter, and section 35 is Aboriginal rights. So, an initiative petition proposal for a referendum must not contravene the Charter or Aboriginal rights as guaranteed in the Constitution. So the question then is, well, what does that mean exactly? And the answer is, well, it's a terrible section because it's not clear what it means. One of the responses would be to say this: well, if you're asking a referenda question and making your proposal, just doing that can't contravene the Charter or Aboriginal rights. You're just asking a question. And that's true, which is why the choice of the word contravene was a poor choice. But on that reading, we just say, oh, you know what? No question can contravene the Constitution. And so we're not going to worry about it because this section means nothing. Ignore it. Okay. Here's the problem. There's a principle of statutory interpretation that says the legislature puts provisions into statutes to mean something. It's unlikely that a court is going to read that and say, oh, that doesn't mean anything, ignore it. It's going to mean something. So the question is, what is it supposed to mean? Okay. Now, here's the context, as many people will know. The APP proposed a question for this petition proposal for an independence referendum. That question was referred by the Chief Electoral Officer to the court. Why? Well, because they saw the question and they saw this section that I just read out. And they thought, well, I'm not sure if that complies with the section, so I'm going to refer it to a court, as they are empowered to do under the statute. So the court now has this same job. Here's the question, and here's the section of the statute. Does the question satisfy or comply with the requirement of the section? And that's where we are right now. The hearing is coming up in this month, and the decision will be out at the end of the year or in the new year.
Now, Bruce, on that note, because I think that's a very valid point to bring up here. So a lot of people have taken offense to the electoral officer for moving this into the courts. But from what you've just said, this was the Alberta government itself was the one who the electoral officer really didn't have a choice, because he's not authorized or qualified to make a determination as to whether or not this question contravenes sections 1 through 35. That really is a judicial question, something that is for the courts, not for, a chief electoral officer to make. Is that a fair assumption?
I think people would be complaining more if the chief electoral officer on his own had decided, I'm sorry, you can't ask this question because it contravenes section 2(4). I think people will be more satisfied to have this in front of a court than subject to the discretion of the officer. And so it's very difficult to complain about following a process that is set out in the legislation. So back to the main point, the legislation is a product of the Alberta Legislature, and the Alberta Legislature is in control, is controlled by whatever party is in power at the time, right? So, the UCP made amendments to this statute not too long ago, and they were largely good amendments, lowering the number of signatures that you needed to get over the threshold to access this mechanism, which is good. But they left this section in there. And so it is the job of the Chief Electoral Officer, and now the job of the court, to figure out what this is supposed to mean and what kinds of questions it is intended to prevent. And that's where we're at right now.
But here's the thing. So you point out, and even in your article, you say the villain here is the Alberta statute and by extension, the Alberta government, either inadvertently or on purpose. It's leading its own people down the garden path. The government and the legislature could easily amend the Citizen Initiative Act to change or remove Section 2(4), but they were the ones who added this section to the Citizens Initiative Act, right? So Danielle Smith came out with a lot of fanfare, and a lot of people got very excited thinking she was supporting a referendum on independence by lowering the number to 177, 177,000.
Yes.
But here we have this poison pill, which basically ultimately ensures, if it does indeed mean that we can't contradict, like we cannot, overrule sections
Right.
1 through 35.1, we could never have a referendum on independence. Am I
Right. So
getting that right?
Yes, there's one correction though. Ron Voss has looked into this a little bit, and so he says, and I think he's probably right, that it sounds like that the UCP did not itself add that section to the Citizen Initiative Act. It was already there, but they decided to leave it in. But they did add the section that I'm going to talk about in the Referendum Act, which is also an obstacle. So I want that to be clear. It looks like that in that amendment process, I don't think that section was added at that time, but it's in there and was left in there to do the kind of role that you're describing. But so we're left with this interpretation question, and this is a technical legal thing, right? But I just want people to understand why this is such a tangle. You've got this section, and the argument, from the APP, understandably, I suppose in a way, is, well, no question can contravene. You can't, simply asking a question doesn't contravene anything. And that's true. But that's not the end of the problem, because the section is going to need to mean something. So what could it possibly mean? It looks like it's designed to prevent certain kinds of questions from being asked. So what kinds of questions are they? The section identifies only some sections of the Constitution. It identifies the sections in the Charter and the section about Aboriginal rights. So there's some questions that can't be asked that relate to those sections of the Constitution only. So what is it supposed to mean? Now, in this court proceeding, the court has appointed friends of the court. That is, people who have been asked to give their submissions about what the question's supposed to mean. And the friends of the court, a lawyer and a law professor from Alberta, have put together a brief, and they have said the following. This section means that you can't ask or propose a question for a referendum if, when implemented, would change, that is, contravene, the Charter or Aboriginal rights. Now, the section's very badly worded. It should say that explicitly, but it doesn't. But nevertheless, that might be the most likely meaning. And how do we know that? Well, because what other possible meaning could it have? It can't mean that you can't ask a question about the Constitution in general, because that would mean you could never make a constitutional proposal. And in fact, it doesn't say that, because it refers only to the Charter in Section 35, right? So if you, for example, if you proposed a question for a referendum that said, we should change the division of powers between the province and the federal government so that Alberta can decide its own way on these things. Okay, that's totally fine, because the section doesn't refer to the sections about division of powers. Section 91, 92 of the BNA Act. Those sections are not listed in this Section 2.4 of the Citizen Initiative Act. So that question is obviously fine. So this section targets questions that might have an effect upon the Charter in Section 35, which independents will do. Because the whole idea of independence is to reject the existing constitutional order of the country you're trying to leave. So if Alberta had a referendum and approved a referendum and negotiated their exit, then it would leave the Canadian Constitution and therefore also leave the Charter and Section 35. And so that is the prospect for why Section 2.4 will be violated, and therefore why possibly the question cannot be allowed.
Now, I'm going
Bottom
to
line, yeah, go ahead.
I got a question, because obviously this, I mean, lawyers drafted this. They knew exactly what they're doing when they were drafting it. The UCP, including Premier Smith, would know exactly what she was doing when she's very openly stated she does not support Alberta independence. This is, in my opinion, and again, my opinion, this was a great stall tactic to give her some fanfare. She could kind of play both sides of the fence a little bit here in a bit of a safety zone, until all this got figured out, right? All this, wording and gone through courts. But I have a question for you, because a lot of people are talking about an Alberta constitution. Alberta needs its own constitution. So law has an order. There's a hierarchy. So if Alberta were indeed, because now we have clause, the Notwithstanding Act that's in the news right now, right? And people saying, about this hierarchy of who can apply what, when, and for what reason, much like what we're doing here. If Alberta were to develop, let's say, its own constitution, and let's say we're still a part of Canada, where would that constitution fall as far as its ability to be applied if, let's say, let's use the gun situation, the federal government comes in and says, we're taking all the guns away, and we have a provincial constitution that says, no, citizens are free to own guns, use guns, have guns, for legal purposes, of course. Where would the Alberta Constitution actually fall into the hierarchy there in the bigger picture?
Okay, so we're assuming that Alberta is still part of the country.
Yep.
That constitution would be a provincial constitution. That constitution would be applied only to those things that are within provincial jurisdiction.
Okay.
And would be subordinate to the Canadian Constitution.
So that's the key. It is still subordinate.
Yes.
Even though we have provincial jurisdiction, because right now, here's the problem we're having in Alberta is the federal government is not respecting provincial jurisdiction.
Right. But to the extent that it is not respecting it, if that is challenged in the courts, then the courts will either say, yeah, you're right, they're not respecting it, and you have to stop. Or they'll say, no, it's fine, don't worry about it. And if they say, nah, it's fine, don't worry about it, then legally that means they are in fact respecting provincial jurisdiction. They're doing what they're allowed to do. In other words, the bottom line for the law is what the courts say the law is. That's the problem. So if the Supreme Court of Canada says, no, it's okay, you can have a carbon tax, feds, you can interfere with provincial jurisdiction to the extent of having a federal carbon tax, no problem. That means that the feds can do just that, because that's what the court said, right? This is one reason why Alberta has to separate, because the Supreme Court over time has shown itself to be inclined towards federal central powers rather than provincial powers. Like, not across the board, not in every case, it's not that simple. But as a pattern, the federal government has quite a lot of room to do things that have the effect of interfering in provincial jurisdiction. Let's talk about the guns for a minute. Right? The federal government has jurisdiction over the criminal law. If the feds make the possession of a gun a federal offense, a criminal offense, then they have the jurisdiction to dictate whether or not you can have a gun. That's in accordance with what the Constitution is describing. And so if you have the attempt at making a provincial constitution that says, oh, you can have your guns, but the federal criminal law says no, then the federal criminal law says no, and there's nothing you can do about that other than leaving the country.
Okay, so that's what I need to understand here, because what we've had our hands now tied provincially to get to a clear question on a referendum. And Danielle Smith keeps saying we can put other protections in place, right? These are provincial jurisdiction. But we've seen a federal government that doesn't honor, provincial jurisdiction at all. And people keep saying, well, Alberta needs its own constitution. But what we're determining here is that that's not going to help, because in the hierarchy of the legal structure, the Canadian Charter, the Canadian Constitution still is got more power. And if the
Yes.
courts, which the pattern is, they tend to decide more with the federal government, even if they do interfere in provincial jurisdiction, what other protections would Alberta have?
Well, so for example, as you will recall, a little while ago, Alberta passed amendments to the Alberta Bill of Rights. And that was sold as protecting Albertans' property rights and guns and other kinds of things. But that Alberta Bill of Rights is an Alberta statute. And as such, it is subject to all the things we're talking about, including the Canadian Constitution, including the Charter, as well as the division of powers, right? So there's nothing that the Alberta Bill of Rights can do to change any of those things we just mentioned. It is subject to the Supreme Court's interpretation of what the Charter means, as well as all the other sections of the Constitution, right? So the federal jurisdiction over criminal law remains. The requirements of the Charter remain. Section 35 remains. And doesn't matter. It does not matter what an Alberta statute called the Bill of Rights says about any of those things.
So Bill of Rights, Constitution, if it's Alberta, it applies to Alberta. The federal government does not have to work within, and there's no protections there for Alberta.
If the federal government is exercising federal authority as approved by the courts, then there's nothing you can do about that.
So here's the bigger threat than the Constitution, because the Constitution does lay out some provincial jurisdictions very clearly as to what belongs to the provinces and what they can and cannot do, and what they can and cannot interfere in. The bigger issue here then is the courts, which are appointed primarily Liberal, and the judgments that they make. So, instead of having this debated now in Parliament, where our legislators, which are elected, which individuals have some ability and accountability that they're held to their electorate, now we have courts who are unelected and appointed that can make decisions that impact its citizens.
And one of the quirks of our Constitution is that the federal government appoints the judges to the highest courts in each province. So the people sitting on the Alberta Supreme Court, Court of King's Bench and the Court of Appeal are federal appointees. Now, it'd be better if they weren't appointees at all, in my books. But nevertheless, they come by virtue of federal appointments, as is the case with all the other provinces as well. This is part of the British North America Act, the Constitution Act 1867.
So not only are they federally appointed at the Supreme Court level, but provincially they are appointed by the federal government as well.
Yes. But back to this proposal conundrum. because I don't want to make this about the judge. I don't even know who I'm not familiar with the judge. I don't know who appointed him. I haven't looked into it. That's not the point right now. The point is not that this judge is doing wrong. This judge is doing the job that the statute asks.
Yeah. And the
And
person who asked for the statute was the UCP government.
Well, the UCP left the section in there. And so what we have right now is uncertainty about whether this kind of question can be asked. And we don't know that until the decision comes out. And it's very difficult, very problematic to try and predict what judges are going to do, because you'll often find out that you're wrong. But nevertheless, there's a good chance that the answer is going to be no. That is, Section 2.4 prohibits this proposal from going forward. There's another alternative as well, which is that the court will say, well, the question can go forward. You can make this proposal. But if anything comes of it, like if a referendum is held under this question, if the referendum passes under this question, then the conditions upon which it proceeds is such that the results cannot contravene the charter in Section 35, meaning that the court could say your hands are tied to this extent. Nothing that happens from this process can change the charter or Section 35. For example, in an independent Alberta, if Alberta passes the referendum and you go into negotiations with the federal government, the court decision might say you really shouldn't be negotiating to end the charter, or at least to end the charter, the effect of the charter. In other words, if you're in this new independent country, you should be reproducing the charter and Section 35. In other words, you're not allowed to have a blank slate, a fresh start. You're obligated to reproduce the system that you have in Canada to the extent of the charter in Section 35. That's one of the dangers. Now, let's be clear. That doesn't make sense either. But nothing makes sense because the section doesn't make sense. The section shouldn't be in there. And the easiest solution to this problem is to have the Alberta Legislature repeal the section. Just get rid of it. It's not hard to do. And there's no reason for having it in there. It doesn't make sense in the first place. So they can just get rid of it. It's not a big ask. Now, let's go on to the second problem. This first problem is with the Citizen Initiative Act and this proposal, Section 2.4. The other problem is in the Referendum Act. And the Referendum Act is the act under which the Alberta government would bring forward its referendum on anything, including independence. Okay. There is also a problematic section in that act. It's not the same, but it's not dissimilar as well. Here's what this one says. This is Section 8.11, bracket 3 of the Referendum Act of Alberta. Nothing in a referendum held under this act is to be construed as abrogating or derogating from the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada that are recognized and affirmed by Section 35 of the Constitution Act 1982. In other words, if you hold a referendum under the Referendum Act, which is the way you're supposed to do it in Alberta, nothing in that referendum can result in derogating from the existing Aboriginal and treaty rights as established under Section 35 of the Canadian Constitution. Your hands are still tied.
We have the Citizens Initiative Act, which now we have our hands are tied. If the government itself puts forward a Referendum Act, which Danielle Smith and the UCP have made it very clear that the government itself will not put forward a question on independence. But even if it were to do so, we are still bound to parts of Canada that we cannot get out from and under. So what you talk here, unless the Alberta government amends its own legislation, the referendum goose is cooked. They do have the power to amend this right?
Mm.
Through
Oh, yes.
legislation. It's a
Oh,
vote,
yes.
right? I mean, it would
Easily.
have to vote. So this would have to go to all the legislature. But I mean, UCP has a majority there. They could pass this to have it removed.
Oh, yes. And not with great difficulty because they have a majority. So it would have to go through the steps, any bill would go through.
Yep.
I mean, for sure. So it can't be done overnight,
No.
but it can be done, and it wouldn't be a big deal.
But instead of having wasted our time, going through a court to make a decision, they could have used that time to actually put this back on the legislature floor and have it removed so that citizens who bring forward a referendum are free to have a referendum question on what they want, not without constraints and, conditions placed upon it.
Right. Exactly so. And I hope it's very clear that this difficulty that has arisen in the context of the Citizen Initiative Act is not in any way the fault of the APP. Right? They have asked a question and
Yeah.
started the process for making this proposal, and they have been caught by this strange section of the act, and they're now caught having to go to court to try to argue why this strangely worded section does not prohibit the question they're trying to ask. And it's a bizarre and unfair task that they're being asked to perform.
Yeah, and one deliberate, in my opinion. So you say here, time for plan B. What would plan B even like? We obviously can't do it through the courts. We can't do it
No,
through, and this is the other thing, like with respect to the Constitution and all these constraints, we're bringing we're what would be the point of leaving if you have to keep Canada in Alberta?
exactly so. I mean, the whole point of this is to be able to start fresh, to ditch that constitutional system that has not served you well. And to do that, you need to be able to make your own choices. And and according to these two statutes, if the meaning is as I'm describing, some of those choices are being made for you already, and your preferences on those won't count, and that won't do. So if this independence thing is to mean what it's supposed to mean, you've got to get rid of those two sections, or you have to figure out something else. My preferred path and the easiest path on this is simply to have those two sections repealed. If it so happens that that's not in the cards, and I don't know why it wouldn't be, but let's say that it's not, then the question is, well, how else can you proceed? And that's what I mean by plan B. And I don't have an easy answer to that. But to be clear, the section of the Citizen Initiative Act does not, and people have said this about the section. They've said, well, that infringes freedom of speech. You're saying we can't ask this particular question. We can ask that question. This is our free speech. Of course you can ask the question. That's not what this is. This is not an unconstitutional provision of the section. This section is not saying you're not allowed to ask anybody whether or not they want to leave or whether or not they want to change the charter or Aboriginal rights. That's not what it says. This section, this statute is creating a process. And all it's saying is that if you want to take advantage of the process, here are the requirements. If you don't want to use that process, you can ask your fellow citizens anything you want. You can hold your own referendum. You can conduct a poll. I mean, it might not be effective. It might be inconvenient. It might be expensive. But you have no charter or constitutional right to have the Citizen Initiative Act. If there was no such act, you could not go to a court and say, we demand to have a Citizen Initiative Act. And the court would not order the Alberta Legislature to enact such an act. If you don't have a right to it, then it can be taken away. And one of the things that maybe takes it away is this section of the act. So there's no constitutional problem with this section. It's just a question of the kind of barriers that the legislature and the government want to have in there to prevent people from accessing it. That is all.
So, but here's the problem though, because, you know, we have a citizenry here in Canada that tries to do things the lawful way, the right way. There's a process, supposedly, if people are, wanting something different from their government to try and change that. And this is what the APP is indeed trying to do, right? They're trying to do this the right way, the legal way, the peaceful way,
Yep.
all those things. But if we don't have a mechanism, which is what right now we don't have a mechanism to have a clean slate, to have a referendum on Alberta independence, even if the citizens themselves were to come out and say, okay, we're going to hire Elections Alberta, we'll hire them, contract them to do this, we're going to have our own referendum. The government, none of that's binding,
Correct.
right?
Correct. 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 Right.
So
But
where's
sure,
the out? How do we get out?
there is no out other than the system of democracy that you already have, which is if you want an independence referendum, you got to elect a government that wants the same thing as you do. If
Okay,
you can't do
so
that, yep.
there is an out. We could elect a government. So whether that's the UCP or another party, but elect a government that would then would at that point then would you need a referendum? Because we've had a vote, right?
Well, the one thing, so let's be very clear. The one thing you do not require is a citizen initiative proposal. I mean, it's great to have this opportunity. It's good to have the statute because it means that citizens can do exactly as the APP is trying to do. But it's not necessary. The government tomorrow could decide that it's going to hold a referendum under the Referendum Act. So you don't need this preliminary stuff. They can go ahead and do it. It seems to me that what the Alberta government is trying to do is to avoid ownership of this, trying to have citizens initiate it, to put the process into motion so that it can be, played out without it being a government initiative. And only they know, what the rationale for that is. But all of this initial procedural stuff is not necessary for the government to proceed with a referendum.
Right. And what harm is it in a government asking a question? In particular, it's a non binding question as to how their citizens feel about staying or leaving in Canada. Like, I mean, I don't understand why they are so fearful of this. I do understand why they're so fearful of this because Danielle Smith and the UCP do not want to. And I should be careful in saying the UCP because I do know there are some MLAs who are quiet and party lines. You're not allowed to give an opinion as to whether or not you support independence or not. But I'm just tired of
Yeah.
listening to a UCP government that says we can somehow negotiate our way out of this with Canada, and yet the trajectory is that Carney and the budget yesterday was very clear. In that entire budget yesterday, there wasn't one time, not one time was oil and gas mentioned.
No, I understand. Yeah.
Not one
Yep.
time.
Yep. Yep. So, but I don't want to attribute any particular motivation with respect to these sections of these acts because I don't know. I
Yeah.
mean, it's possible. It's possible that when the original 2.4 was put in, and I don't know the history, but it might have been it might have been an appeasement to somebody or something in the legislative process. This happens politically all the time. It might have been a blunder. I mean, sometimes sections are put in there whose meaning turns out to be other than what was thought to be the case. Or it might be a poison pill. I mean, who's to know exactly why a particular section ends up in a statute? But the fact of the matter is that it's there. And whatever the reason was for its creation in the first place, it doesn't make sense. It's an obstacle. Take it out. And the same thing goes for the section in the Referendum Act. I also don't know what the motivation there was. I don't know if it was intended to frustrate. I don't know if it was an appeasement. I don't know if it was a mistake. At this stage, doesn't matter. Doesn't matter why. Just take it out.
Yeah. So we have a path forward, and the government has the ability to do that. And this is what its citizens right now are demanding. It's just an honest question. Even the Thomas Lukusiak question is, do you want to stay or do you want to go? And that's passed through, so it's
Well,
I
right,
don't
but
understand here the
the
resistance.
yeah, the control is still in the government's hands, though, as to whether to have a referendum and what the question is going to be, and that proposal, as I understand it, was initiated as a policy proposal rather than a constitutional one. I mean, a constitutional proposal, by definition, involves or proposes an amendment to the Constitution, and a policy proposal doesn't do that, and this one is not proposing. And yet, the flip side of the answer would have the implication of leading to a constitutional amendment that leads to independence, right? So it's a very strange territory, right? That these things start not to make sense, and the easiest way through is just to be plain and simple and say, right, we're going to have a referendum on independence with a clear question. Let's get on the horse.
Yeah. Yeah. Okay. And so if this UCP government does not want to do that, the only plan B that is available would be to re-elect a different government.
Well, let's maybe not go quite that far right away. I mean, the other way to do it is to demonstrate, if you like, to your sitting government the public's stance on this,
Mm.
to show them that this is what the people of Alberta want, and that it is in the interest of Alberta as well as in the interest of your government to provide this, because that's what your voters want. And the holding of an unofficial referendum, whether it's it won't be an official referendum or a series of polls or whatever it is you can think of, to demonstrate the level of interest in this, will help persuade your own politicians that this is where the parade is going,
Hmm.
and that it would be in their interests to be at the front of the parade.
Yeah, I'm just not sure how much more, Albertans can do. The polls are showing 40 some percent in support of Alberta independence. You would think that that would already be enough to say, maybe we should put this question forward and ask, and determine, where people do stand on this, as opposed to having those citizens. Because I think, I mean, there are political implications. I think what Danielle Smith trying to sit on the fence is doing is taking her party, her base, and putting them on one side of the fence or the other, which, she's splitting her base. Personally, I think that's a very dangerous place to be in right now, because, we do have issues that need to be attended to. And politics is just a numbers game, right? Votes,
Mhm.
one vote. Right. And it's not about you have to have 60% of all Albertans. You just have to have enough votes for that party, to become the sitting government. So, I think splitting her base right now is a very dangerous place to be. And I know she's literally trying to ride a line, but at some point she's going to have to make a decision here as to which side of that fence she wants to sit on.
Yes,
Um,
and many people know an awful lot more about Alberta politics than me.
yeah.
I'm on the outside. I'm not attuned to this, but it does, from what I've heard, it sounds like there's some division inside her own government caucus and party, even on this. People with very different opinions about both its viability and its desirability. So, who knows exactly what the dynamics are that they're working with inside there, but it's becoming a problem.
Yeah. Yeah, one that it can't be ignored. She should be addressing it, in my opinion. Okay, that any last kind of words on this? Because you put this out, and to say that the referendum goose is cooked means is somewhat, there's really nothing we can do. We are back into the hands of a government who has to decide to remove a section of these Referendum Act and the Citizens Initiative Act,
Right.
realistically, for this to move forward.
Well, I should say that, listen, I could be wrong. I mean, it might be that the court decides, yeah, the section is meaningless, I'm going to ignore it. I mean, that would be unusual, but nothing is impossible.
Mm.
So my message, though, back to the basic message, is the problem is just two sections of these two statutes that can be easily taken away, easily gotten rid of, easily repealed. And so the best way out of this is simply to do that and get on with the show. And people should not lose sight of the fact that this problem is a made-in-Alberta only problem. It's nothing to do with the federal government or federal law or the Constitution itself. I mean, the fact that these sections of the Alberta statutes refer to the Charter in Section 35 does not mean that the problem is based in the Charter or Section 35. This is not the Charter saying you can't do this. This is your own Alberta statute putting a problem in the way. So just get rid of the problem.
I like that. Just get rid of the problem. Any final words on that?
No, I think that will do for now. Thank you, Nadine.
Just get rid of the problem.
Get rid of the problem.
On a separate note, I just want to talk to you a little bit about my book, Alberta Rising.
Yeah, great.
Yeah, so because we were supposed to do an event, and of course I missed it, and people were kind of, because you and I seem to align on so much, and then they're like, "But Nadine, in your book, you talk about public education, you talk about public health, you talk about all these things that don't necessarily align with the Constitution and some of the things that you and I have discussed." And I keep reminding people that the book is not really written for me. The book is written to spark critical thought and discussion amongst friends and neighbors. Now, you read the book, you provided me with a lovely testimonial in the beginning. Is there any reason why a freedom group should not or would not want to support this book?
Oh, I can't think of one. That's an odd question.
Well, we have some groups that just, you do your thing, and they don't want to lend a helping hand to get the message out. Like, is there something in the book that you read, that you interpreted, that, would be offensive to the independence movement, or in some way, shape, or form, an obstacle to the independence movement? Or do you think it helps the independence movement?
Well, I would have thought that it helped, but so I'm going to try and put myself in somebody else's shoes. The one thing that it does that I like is that it tries to make people think. And when you do that, you risk making a bit of a mess, right? So it's just the opposite of trying to herd people into a particular spot. And that means people can go all over the place with their thinking. It's like they can prefer this or that. And that means that everything is not nice and neat and orderly and controlled towards a particular destination. In other words, it's the difference between sweeping things under the rug or lifting the rug up and seeing what the mess is underneath. And so, some people might be inclined to think, look, our best shot moving forward to get through this threshold is not to talk too much about these things. Let's just get a yes vote, and then we'll worry about it. So if that's their thinking, then your book has the potential for disrupting the landscape with all kinds of uncomfortable ideas and conversations. Maybe that's what you're talking about.
Okay, yeah, because I'm just curious. For me, I've always looked at, get things out into the open, have the conversation. And the book was really designed to, do exactly that, and because nothing's been decided after the yes vote, these are all conversations that kind of need to be had. It was about, whet people's appetite, get them to think, and really bring people over who are on slightly left of center back to maybe, looking at these particular issues and going, why do we do things that way? Because, there's three options. There's really three outcomes, I think, to the whole independence conversation. One is the status quo, which I don't think
Yes.
anybody in Alberta is happy with.
Right.
Right. And that's where the book was written. The status quo is not acceptable. So what changes do we make? Now, the other two options for most people are, we have independence, full 100% autonomy, which we need to get to yes on a referendum vote, Or we get to yes on a referendum vote and we make changes. We negotiate changes within Canada. That's what I see, right? I mean, and then I guess you could always add in the 51st state option, but I don't really particularly care to become the 51st state. So, I see those two options as being very real. The first one being 100% sovereign. We're our own country. Let's start with a clean sheet of paper. Let's do it right, and move forward. The other one being, if we can get to yes on a referendum, and I see yes on a referendum as the solution to any of these outcomes, and we go back to the negotiating table with Canada, what are we negotiating? Well, now you have to have a government that aligns with the values and the things. Again, the conversation still has to be had. How much freedom do we want? How much of our freedom are we willing to give up? And in what areas?
Agreed. And earlier in this process, the argument was made that we shouldn't really talk about contentious things. We should wait until the yes vote occurs, and then we'll deal with those things then. And at the time, I was sympathetic to that view, but my opinion about that has completely changed, because it's kind of too late then. You don't have enough time, first of all, to start from scratch and say, all right, we've all voted yes for independence. Now, what does that mean? You got to sort of know what it means before, because the path, in effect, is going to be determined before you hold the vote, because there's going to be a kind of consensus, certainly amongst the people who are leading the charge, about the vision that they're pursuing, right? So that vision has to more or less crystallize amongst the people during this journey towards the referendum vote, because that vision is going to determine the way the negotiations occur and the kinds of things that Alberta is going to demand at the table for the conditions upon which it's going to leave, right? And the fact of the matter is that there are propositions that have been put on the table about what that looks like. Okay? If you have any of those, and I've put some of my own on there, but it's not just me. So once you have proposals on the table about what this might look like afterwards, well then, now the genie's out of the bottle. You got to talk about it now, because whatever is there is going to be the path forward. So if you don't want what's there already, then you better talk about it. And that's why it needs to be discussed thoroughly and controversially and argumentatively, openly, right now, so that we start to get in Alberta and it's not going to be unanimous. There's no vision that everybody's going to agree with, but you will get starting to develop some kind of coherent vision about what people mean by being an independent country. They've got to have that, and the people who are leading the charge have to know what that is, so that they can pursue it. And there's no reason there's waiting for all of that until after a referendum is not, in my view, not feasible.
Well, I mean, I just use the Alberta pension plan, for example. Some people look at me and go, Nadine, but you want independence. Why are you even talking about an Alberta pension plan still? And it's like, well, Alberta independence is not guaranteed, but there are things provincially that we can and should do. We should be still, in my opinion, I keep calling it parallel activity, still be working towards bringing back under our own banner what we can. And an Alberta pension plan being one of those. Is like, you can't change what you do not control. Right? So the first step is to regain control. So an Alberta pension plan, for example, regain the control, then we can make the changes necessary that we want to see. But, what changes do we want to see? Right? Like that those are conversations that need to be had. But for me, again, first step, yes on a referendum. It doesn't matter what you want, whether you want 51st state, whether you want independence, whether you want just to renegotiate a better deal within Canada. We have to have a yes on a referendum vote, because we have no leverage otherwise.
No, well, that's true. You have no leverage right now. That is true. Except on those things that are already within provincial jurisdiction.
Yes.
So right? So the pension thing and the
Policing, taxation,
policing,
revenue
that
collection, all those
yeah,
things are things that we should be, could be bringing back home to Alberta.
let's just be very clear. Th that list of things has nothing to do with independence.
No.
You already have the jurisdiction to do those things if you want to. It's got nothing to do with Ottawa. Ottawa's not preventing you from doing that. You can do that tomorrow if you want to. It's just that it's sometime in the past you decided not to, which is fine. If you want to change your mind, change your mind. But those questions are apart from the Ottawa questions, from the independence questions. And one of my concerns is they're all getting mixed together.
And
Um,
that's my concern. So what we have here is we have people that are going, it's independence or nothing. Well, the independence movement, I hope and I pray that it happens. But the reality is there are things that Alberta can do today. This government could implement tomorrow. And this is where you had mentioned earlier about the Citizens Initiative Act, and this is being an obstacle. I have seen this UCP government put other obstacles in our path to things that we could and should be doing, like the Alberta pension plan, right? She has put in, and the government, the UCP government, has added a clause in legislation, a bill that says we have to have a referendum provincially in order to
mm,
move forward with an Alberta pension plan. Well, why would
mm.
you put an obstacle in your path that was not there and is not there federally or in the, Canada Pension Plan Act? Why would you add obstacles to your own path provincially, not only for this government, but for any and all future governments, right? That's the problem with government. It doesn't just apply to one, it applies to the entire future. Once something has become enacted in law, it is there until it is removed, right? And everybody has
Yep.
to abide by it. So, this is my concern. We see these things that can be done, and instead of stroking the pen, doing what needs to be done, we just see obstacles. And to me, that's not leadership. This is trying to manage, well, it wasn't my fault. This is what people wanted. This is, it's like I'd like to see some leadership in this province. Like, make a decision. Let's make this happen. Why? Because it is the best thing to do for the people of this province,
Agreed. Agreed. There's no reason to have that section in there.
right? Right.
Yep.
Okay. So, for me, I always like to get an objective opinion. I've had people who go, well, so and so is not supporting this book. And I'm like, well, why are they not supporting this book? Is it something that I've, put in the book that, has a contrary effect to independence? Because the book was really, truly meant to bring more people into the independence conversation, so that they could see a vision of what Alberta can become. And it's given examples, around the world, whether it be Saudi Arabia because they don't pay personal income taxes, whether it be voucher systems in some of the states on an education perspective that have better, again, results, better outcomes. Japan, who, if we insist on keeping a universal healthcare system, then my gosh, we should at least have the best we can possibly do, right, Bruce?
Spreading all these dangerous ideas, Nadine. Really, shame on you.
I think there's a UCP conspiracy. Like, they just don't like Nadine, right? It's like none of her ideas. Don't let any of them get out. Awesome. Well, thank you so much again for your time this morning. As always, it's a pleasure. It's just nice to bring some clarity as to where the problems truly lie and what the solutions actually are, and to break it down in a way that people can understand. Because the government, just like last night's budget, will use words that don't necessarily mean what they say. And then, of course, they try to hide behind a lot of, decisions and a lot of finger pointing, like this is all Trump's fault. No, it's not. These conditions in Canada, our productivity was way down long before Trump. But, they are always looking for somebody else to blame. And so
Right.
I
Right.
like to clarify for people where the blame lies, but more importantly, where the solution lies. And in this particular case around, the Citizens Initiative and the Referendum Act, it is quite simple. It will take a little time, as you pointed out, but a simple solution is just have them removed so that people can truly, honestly put forward a referendum question on any topic that
Yes.
is, true and near and dear to the citizens. And, it is then the government's obligation to move forward with those questions.
Right. Right. And an awful lot would become clear if, like, the process of going through the legislative steps will take a little bit of time. But even if we had a government bill that was put on the table and said, here's what we're going to do, we're going to remove these two sections and start the process, well, then the whole thing will be cleared up. It might not be finished for a bit, but at least what's going to happen, and that would help to clear the path. So
Yeah. And the messy
I'm not
part,
worried about I'm not worried about the delay. I'm just worried about the initiative, the impetus to do this.
yeah, and the messy part of that would be it allows, I think, citizens to truly garner more insights into the political process and into their MLAs, right, that they've elected. Do they align with the citizens in their constituents, or is this a party that is going to do its own thing outside? So I just think there's a lot more to be garnered had the government chosen to just look, let's put this back into legislature, let's have the debate and the conversation, because I think it would have opened up the window for citizens to actually see who within legislature is supportive of honest, true referendum
Mhm.
questions, and rather than hiding behind, well, there's an act, it's got to go to the courts, we got to let them decide, it's not our fault, right? Because this is what happens time and time again.
Right. 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 Thank you for having me on to talk
Ah,
about this. It's very important. Yeah.
well, Bruce, I'm still waiting. It's like, have you got your house picked out? We
Not
we
yet.
need to talk
Not yet.
about, because I think honestly, you and I need to talk anyway, because I think we need to establish a committee of
Mhm.
individuals like yourself,
Mhm.
myself, John Carpe, there's a few others who I think we
Mhm.
need to come together to, you know, do some messaging of our own as
Mhm.
to what the next steps are and to paint that vision for Albertans. Because I think so many people here look and go, but who's going to take this on? Who's going to do this? And I think there needs to be more voices added to that, because I'm
Mhm.
seeing divisions that happen, but
Mhm.
one that's inclusive of the citizen, that allows them a voice to say, well, this scares me, or this doesn't, or what about this? Somewhere where they can bring their ideas forward and have the debate.
Agreed. Agreed. That you need that. This is what this is all about. I mean, the whole proposition is that the people of Alberta can decide whether or not they want to stay or whether they want to go. Right? It's a there are lots of situations in which democracy is not ideal, but this is a democratic decision to be made, and it's important that the people be able to make that decision on their own. So anything that leads to that result is a good idea.
Wonderful. Awesome. And on that note, everybody, we are going to call it a day. And I hope you enjoyed the show. Please do please do share your support, whether it be through a donation and or just sharing the videos. Help me bring guests like Bruce back onto the show and help keep the message alive and getting it out there. If you have not picked up a copy of Alberta Rising, it is available on Amazon. If that's not an option for you, reach out to me personally. I'm not hard to find, and then you can ask. I will be happy to send you a copy of the book as well. So, Alberta Rising on Amazon, it is a great book. It is meant not to give you the answers. It is written from a place of principle, not a place of policy. It is written for the purpose of sparking that conversation with friends and family and for getting you to think about the issues and what it is you truly want. So all Albertans we can all walk the path together in the direction as to what we want rather than what we're being told we must have. So God bless you all. Have a great day.